Welcome everybody. My name is Jeff Fowler with the Apartment Owners Association. It's great to have you with us today. Today we're going to be talking ADA compliance and specifically those accessible routes. And so before we get into that, AOA's been around for over 40 years, one of the largest individually organized groups of apartment owners here in the state, and we are so thankful for you. And even this morning, we got a nice 5-star Yelp review from Alpha F. So thank you if you're watching today. And they wrote, "I've been a member for many years. I think one of the benefits is the monthly magazine. It discusses the FAQs, which are current and relevant. The other benefit is the forms available for the members, including the lease, application form, and a 3-day notice, etc. One other benefit is that you can call and ask for advice. They may not have all the answers, but they can direct you to relevant professionals. It is an organization that landlords should be in and be united and educated." So thank you so much, Alpha F, for that one. Really appreciate it. And so just great. Just so thankful for all of you. And those Yelp reviews help. The Google reviews all help, and everything. So thank you so much. And if you have not ever been a member, there is a 100% money back guarantee in your first year. So definitely give it a try if you haven't. And then also coming up later today at 1:30, we'll have a legal Q&A for San Diego with landlord tenant attorney Franco Simone, and with new laws being passed there, and also this being the time when you're filling vacancies. This is just a critical time to talk through what you do before you hand over the keys, and that'll be specific to San Diego, but there'll be some good general information there for everybody. And anyway, today, if you have questions, there's the blue help button down at the bottom of your screen if you're on AOAUSA.com. And then also there's closed caption on Facebook, so you can get it on Facebook Live right now and get the closed captions if you need it. And also just want to thank ARC Design and Build for sponsoring today's event. And they also have a sister company, ARC Concrete and Asphalt Construction. They're based in Orange County. However, they cover the entire state. They do have a satellite office up in Northern California as well. And they do go for, it's just a complete solution for ADA compliance. So whether it's responding to a lawsuit or whether it's just construction, they're improving access for individuals with disabilities by providing information, education, and access to compliance solutions. So anyway, very excited about our speaker today. He's the owner and founder of that. Just such an accomplished person, decades of experience. He's got tons of licenses, A, B, C12, C8, and C32. And so it's my pleasure to introduce to you today, Tony Guichard.
Confirm that everyone can hear me and everything is good. So with regards to the accessible route, possibly a good definition would be if you had a small commercial center or a strip center that consisted of 3-4 units, example, a liquor store, donut shop, nail salon, there are site arrival points within that property, not just the disabled parking stall. And a lot of property owners are confused that the only item that they need to provide is a disabled parking stall and a sign. However, what's really required is a complete accessible route. Even with apartment complexes with 15 units or more, that may have a leasing office or an on-site manager. Those two items within the apartments are subject to public accommodations because the leasing office is open to the public. So anybody who owns an apartment complex with 15 units or more, a leasing office should be aware of this as well. So before we dive into the details of the accessible route, just a couple quick introductions. You're going to hear me speak today about team. In order to provide a complete accessible route, the design, a city permit, things of that nature, to really provide it correctly, you need three key principles. Myself, I act as the designer and the contractor. I perform the civil engineering and the architectural design. We have our CASP inspector is Jason. Now, Jason is not an employee of ACR. We do that for the purposes of any conflict. So Jason performs our CASP inspections and our reports, and I consult with him with regards to the design. In addition to that, if you happen to be caught up in an ADA lawsuit, we have our team attorney, Tina, again, who is not an employee of ACR, but a separate entity, again, for conflict. Today, we're going to be going over multiple items, and I will not be giving any legal advice. However, again, we have our legal counsel in the event that you need to speak to a qualified ADA attorney. Just a quick oversight. ACR has been around for over 35 years, family-owned business. We provide ADA compliance with planning and design, with the engineering, the CASP inspections. We manage all the city permits and inspections. Those can be very troublesome in today's world in acquiring a city permit and knowing how to manage and navigate through them. And again, we have a lawsuit consultation team that you can reach out to as well. Today's agenda, we're going to be reviewing the accessible route. 4 key items into bringing your property into proper compliance. Starting, be proactive with the CASP report. What I mean by proactive is obtain a CASP report before a lawsuit is filed. That way you know your exposure and what the corrections are. Do not listen to contractors, architects, or city officials. That's why these CASP inspectors have been put in place. They are experts. Design, then corrections, and CASP reinspection. Very critical, the CASP reinspection after work has been performed. The ADA retail lawsuit case study. We're actually going to be reviewing a actual lawsuit or complaint and the allegations within it, and the importance of the CASP inspection and the report, and how we compare the two. Reviewing the actual property correctly for the accessible route, and how to bring the property into full compliance. These types of lawsuits are hitting the retail and commercial centers, and here most recently, the apartment buildings with 15 or more units and a website. They're attacking the path of travel to the leasing office and the websites. So if you have a property management company, make sure that their website is ADA compliant. That is becoming a very, very popular allegation at this time. Some of the challenges owners face. Protection the first time with a good CASP report. If you're not obtaining a CASP report or inspection from ACR and it's another individual, be sure and ask them if they actually work for the plaintiff side or the law firms that file these lawsuits. We're finding that there's a large percentage of CASP inspectors that are also working for the law firms that are filing these lawsuits. If that's the case, it's our opinion, you do not want these entities or persons on your property for a variety of reasons. The next thing is make sure that your designer and contractor are qualified. Check their experiences. Check, do they provide formal plans and permits? ADA or disabled access work does require a city permit. It That is very important. And the permit provides a threshold on and when the property was brought into compliance. That is a key element going forward with the property. Most contractors, architects, and city officials fail with ADA compliance. The asphalt contractors and concrete contractors, architects with limited knowledge on ADA and what we refer to as the California Building Code, specifically to 11B, and the city officials fail. Again, this is why the CASP inspectors are in place. The accessible route. We're going to review the accessible route all the way through from a particular point where a lawsuit may originate. And we're going to follow it through. And here we have the lawsuit allegations, where we will review the actual allegations and how they compare to the CASP report. Oftentimes when a lawsuit is filed, it's a cut and paste item, meaning that they will name 10 or 15 items that may not be accurate. And the way that you validate if they're accurate or not is you compare them to the CASP report. The CASP report will be precise and give you the exact information on what the corrections are on your property. The lawsuit may have 20 corrections alleged, and your CASP report may come back with 3 or 4. That's critical because it reduces the amount of the settlement ask. If you have a good attorney, the CASP inspector and the designer, myself, will be able to work with the attorney in order to say, yes, this correction is valid, and no, this one isn't. Therefore, it reduces the ask for the settlement. This is a perfect example of why a team effort is important. If you pick your contractor and a CASP report and an attorney, and they don't work together on a daily basis, you may not be in the best position to resolve your property going forward, and you may have multiple lawsuits. So are the allegations actually correct or are they made up? And how to confirm and why this is critical. And I think I just covered that. Discuss what the property owner should actually correct, just the allegations or corrections per the CASP report. It is our opinion that you are always best to make the corrections per the CASP report. If the property lawsuit alleges that there are only 2 or 3 corrections, such as there isn't a van accessible parking stall or the striping, and you only correct those items, and you do not take into consideration that the detectable warning domes are missing, the city path of travel is missing, you are leaving the door open for a second and third lawsuit. So again, in our opinion, always pay attention to the CASP report and review the exposures for property owners for multiple lawsuits. And the way that you review those is you compare the allegations versus the CASP report and make sure that your legal counsel is giving you direction to make the corrections according to the CASP report and not simply the lawsuit. So here's an example, and this is where the accessible route is going to start and maybe be able to define it a bit better for you. So I put some arrows at the top. So what they're alleging in this particular lawsuit is the parking spaces, access aisles, and I put an arrow on the path of travel, which is another term for the accessible route. So if you come down to the next arrow, letter A, they're talking about the property lacks the minimum required ADA compliant accessible parking stalls. B, the striping on the blue border wasn't correct. C, the parking spaces are smaller than what they're supposed to be. So these are very minor items. However, a lawsuit was filed just because of these very minor items. So as we go into, I'm going to skip over this page for now. I'm going to go into the actual CASP report that we performed against this particular lawsuit. Now, keep in mind, this lawsuit has alleged that the striping wasn't correct, so we need to verify that by a CAS report. So here's what a CAS report looks like. You can see the ADA parking stall down below in both of these pictures. And if you look at the top, there's some findings that the striping for the access aisle has corrections within it. This arrow will show you that the striping is superimposed over older striping, making it confusing. So what happened here is the owner has hired an asphalt contractor over the years, and they've done a poor job in striping these parking stalls. So if you look underneath here where my cursor is, the diagonal stripes you can see are white. However, in the parking lot, they've striped them blue. The words "no parking" cannot have a line going through them. And if you look at the close-ups over here, you can see that it's very confusing. You have the black stripe out here that was previous, and there's just been multiple times that they've done this. And because the asphalt contractor didn't have a true understanding of how to perform these tasks, the owner ended up in a lawsuit. So what we would have to do is report back to your attorney and say, look, the allegations in the lawsuit, unfortunately, are correct. So do not spend a lot of time defending those. Look for a simple way out and cut your costs as quickly as you can and make the correction so it doesn't happen again. A lot of times, your CASP inspector or your designer will not speak to your attorney, and your attorney doesn't have this information, so they can't fight to reduce the ask in the settlement. So in this particular instance, we would have to come back to your legal counsel and inform them that the lawsuit is actually correct with these allegations. Now, as we get into the second page of the CAS report, it's starting to talk more and more about the accessible route. So down here in the bottom left corner, you can see this sidewalk. I've drawn the blue lines there on the border that should be there. And unfortunately on this property, they're missing. So you need to create a path of travel from your shopping center to the public sidewalk. Now, within that accessible route or that path of travel, it has to be free of barriers, meaning that the path of travel within that blue border, it can't have cracks in the asphalt. It can't have more than 2% cross slope. It can't have more than 5% slope in the direction of travel. In addition to that, you can see the level on the detectable warning dome. This asphalt contractor has chosen to put a surface mount dome on, which presents a lot of problems. They become loose over time and they create a trip and fall. In addition to this particular case, on the right-hand side of that detectable warning dome, you can see a big gap. That gap cannot be there. The maximum is 2 inches. This is about 6 inches. So in order to create a accessible route within the ADA guidelines and California guidelines, you really have to know what you're doing. And if you come over to the second page, at the top, it's called Finding 6. So as you look at the findings, it's going to tell you that there are certain percentages and cross slopes that this particular accessible route has or is in need of corrections. So here's this next page. I've taken and made a note here, 2% maximum. Now, as you can see, our level below it, it's at a 3.7. And again, if you look at the detectable warning domes, they are surface mounted and there are large gaps on either side. Now, that landing needs to be reduced to 2% maximum. So the contractor who put this concrete in years ago is probably long gone. The lawsuit has been filed Now the owner has to go back and figure out how to correct this. And unfortunately, the only way to do it is you have to remove and replace a considerable amount of concrete. Had the owner had a design with a city permit and a CASP reinspection, that would have eliminated this problem. If you come to the second page here, finding 7, again, it's talking about the accessible route. So on the left-hand side, you can see the 5% maximum where the level is. Underneath is the actual level. It's 5.5. Now, since this concrete has to be torn out, you may as well attempt to try to put this back in at 5% since you're very close. Currently, you're at 5.5, but you have to remember the landing on the left-hand side needs to drop about 3 inches. So that will increase this to about 7 or 8%, which means that little portion would have to have handrails. And the reason I'm bringing this up is there is a considerable amount of design and civil engineering that goes into putting a correct design together and then knowing the law and the codes and how to apply them. So be very careful when you're hiring just an asphalt contractor or a contractor to perform these tasks without following the 4 steps. CASP report, city permit, plans, and reinspection. So over here on the right, we have finding 8. This is another correction. As you can see, the path of travel across the driveway, the paint marking is not visible. The slope with the cracks in the asphalt need to be repaired. And on the far side, the detectable warning domes are not wide enough. So this is all identified through the CASP report. So that's why you want to pay attention to the corrections in the CASP report. If you only make 2 or 3 of the corrections, you are still vulnerable for the outstanding corrections. So it's always imperative that you work towards making all the corrections and have a clean city permit that's signed off and a CASP reinspection that shows all the corrections have been made. Again, this ADA work and the corrections within the accessible route do require a city permit. There are a variety of reasons why, and they do protect the owner. That will require a formal set of plans and the submittal process. You want to review how the allegations, again, differ from the CASP report and the actual site plan. Review the completed site plan showing a complete accessible route, not just the parking stalls. So here's a property that we just completed about 3 months ago. Client came to us. They had up to 3 lawsuits on this property and felt as if though that each time they had hired competent asphalt contractors to make the corrections for them. So this is a plan view looking down on it. This is the building down here, and there's also a building on the right. So there are entrances here on the right, and there are entrances down here on the bottom. So this property doesn't have a current ADA parking stall, which is what prompted the lawsuit. It's actually buried down here in this corner without an access aisle, the crosshatching, and it's not compliant. So we had to come in and prepare a design and perform the work and bring it into compliance. So this slide shows what we actually did and how we brought the property into compliance. So you can see we start with the 2 disabled parking stalls. There's a blue path of travel that connects them because the buildings on the left have their entrance doors where that arrow is on the left. So in order to get to them, you can park here or here. There's an accessible route that comes out to the city sidewalk, down to the left, and then comes down to the staircase. And there's a ramp that we built that comes up to the units. So these buildings are part of this parcel, and their entrance is all far to the left. So if you were a contractor, you would never even consider the accessible route that's required to all of the entrances to the property. For instance, if this particular individual came across and went to the entrances and wanted to go to the bookstore and then decided they wanted to go back out and come to the bank, that red line depicts a complete accessible route that's required. And each of the orange arrows shows you a path of travel. Now, again, within that path of travel, it has to be free of barriers. The slopes have to be correct, cross slopes, the striping, everything that's within the accessible route must be perfect. But this gives you an idea on what is really required. Oftentimes, the property owner may have been sued for not having a van accessible parking stall, which was the case here. The property owner paid attention to the lawsuit, did not obtain a cash report, and simply attempted to hire an asphalt contractor to stripe the stall. Then came the second lawsuit, which was there was no path of travel to all of the entrances. Then came the third lawsuit, which said there are not enough disabled parking stalls and they are not dispersed correctly. So they finally said, I give. They came to us, we put the plan together. We had it CASP reviewed before we submitted to the city. City reviewed it, we built it, city signed off on it, and we had a CASP reinspection. So now this property is in great shape. This next slide shows the extent of the accessible route as it relates to your tenants. So this particular case, this was a donut shop. And keep in mind the accessible route will go to the accessible entrance. Now, once they're inside the retail unit, the donut shop, most of your leases will state that the tenant is responsible and liable per local codes for the interior of the unit. But one of the questions is, and you should consider this in your leases, who really has liability of the entrance door? And the reason I bring that up is the particular doors can be quite expensive. By the time you adjust them for the 5 pounds of pressure and the closing speed of 5 seconds, you may have to change the closer. You may have to add the 10-inch smooth plate. By the time you're done, it may require a door that's anywhere from $3,000 to $4,000. So you may want to have that outlined in your leases, that who has liability of the door, because that's the defining point. So complete ADA retail compliance. Conveying the importance of having a complete ADA team in your corner. The reason I have put a team together is because I know the principles that you need to resolve these lawsuits or to be proactive to avoid the lawsuits in the most economical and stress-free way. If you elect or opt to hire these individually, you don't have a quarterback to help you navigate through. Hiring a complete ADA team, inclusive of the designer contractor, CASP inspector, and ADA attorney. Those 3 principles, or actually 4 principles, are very critical. How they work as a team to provide the best level of protection. Now, the documents that your team can provide to assist from multiple lawsuits starts with a CASP inspection and a report from a qualified CASP inspector. I see CASP reports range from $100 to $1,000. An average price for a 3 or 4 unit property strip center for the exterior only would range anywhere from $400 to $600 typically. And it should use a blue DAG form, which is very clear for all to interpret. Once you have your CASP report, a formal design and plans, a city permit, and a CASP reinspection. Those are the documents you want to end up with to provide a complete protection for your property. And again, I can't stress enough how important it is to work within a hiring of a complete team and paying attention to the complete accessible route, not just a disabled parking stall and not just a curb ramp, making sure that there is a route to all the entrances from the disabled parking and from the city sidewalk. Keep in mind, not all disabled persons operate a motor vehicle. 35% navigate by public transportation and the city sidewalk. So there needs to be a path of travel from the city sidewalk. In addition, if you have a property with multiple buildings on it, let's say you have one building with 3 units, you have to cross a driveway, and you have another building with 6 units. You have to link them together internally so a person can navigate from one building to the other building with a path of travel. So linking them together is also part of the accessible route. So I hope I've been able to add some clarity for the accessible route. And if you ever have any questions, you can always email and I'll get back to you as quickly as I can.
Excellent. Tony, thank you so much. And you guys may not be able to see it there. We'll get his phone number up. But yeah, and it's ACR Concrete Incorporate Inc.com is the website. So you can check that out. And Anthony, let's get him back here. And hopefully we'll get a split screen. And now is the perfect time for questions. Again, if you're on the AOAUSA.com, you can put your questions in. We already have several questions, and we can just get right to it. Thank you so much. Again, the first one on YouTube, we have Kong. And for an apartment complex with an exterior entry gate, must the entry gate doorknob be a lever type, or can it be a round knob type?
It depends if it's part of the accessible route. Now, if it's within the accessible route that's required, so what I would have to say is we do or perform scoping first. So my first question would be, is the gate leading to a leasing office? Does the property have a leasing office? Is there a manager on site? The first thing that comes to mind is if it's an apartment building with a leasing office, typically the gate would lead to a path or a set of stairs to the front entry door. Now, if there's a leasing office, then you need to have a ramp. If it were a gate that's in the accessible route, then there are a variety of things that have to come into play. You would have to have what we call a maneuvering space on both sides of the gate. The gate would have to be minimum 32 inches. The door lever would be required, absolutely. And you need to take into consideration security. Does the gate have a latch, a locking mechanism? And then you would have signage that says, call a certain number. But the key part would be, is this going to the leasing office or is it going to a parking lot? If it's not within the accessible route, then it's not required.
Great. And then Fu on YouTube. Each unit has an assigned space in a multi-unit apartment complex. There are no handicap parking spaces. Is a handicap space required?
The question I would ask is if it's public housing or if it's covered multifamily. So I'm assuming it's covered multifamily and does not use any type of federal funding or partnership. So if it's all assigned and there are no disabled parking stalls, then you would go back to the original code that the building was built, let's say 1980, and what was required at that time. If you haven't touched it, if you have a building that was built in 1980 and you complied with all of the codes, and then you decided to add a couple more units, now that's going to trigger current 2010 ADA, and it's going to trigger 2022 with regards to 11A and B. So that would be the scoping that I would ask up front. But if you don't have a leasing office and you do not have an accessible parking and all is assigned, then I would highly suggest placing signage at the entrance to the parking lot that all parking is assigned and there isn't any guest parking.
Very good. All right. And that kind of leads into the next question that Ken has for us is, are there any properties grandfathered from compliance? And so you kind of answered that. For example, a 2-story apartment built in 1958. Do I have to add an elevator?
The answer on that would be no, because it would probably be technically infeasible. Now, if you had room to add multiple units, which most properties typically do not, then that would come into play. Then the question would be, is it public housing or is it private? Then each one of those scoping requirements would dictate whether or not you would have to put an elevator in. Again, if this property is under 15 units and has an elevator, then it's not open to the public. The only time it triggers ADA compliance is when you have, for lack of a better phrase, something on the property that's open to the public. That would be the leasing office and the on-site manager. Typically, the way the courts have reviewed it, my opinion, is the on-site manager, part of his daily duties is to entertain potential tenants, whether it's giving them leasing information or documents or credit apps and things of that nature. So if he's going to do that and his unit is on the second floor, then you need to create a path of travel to a common area, maybe by the pool, with a disabled table with a shade structure over it, where a disabled person can at least inquire. You don't have to necessarily remodel your units, but at least afford the possibility for a disabled person to inquire.
So, Tony, you had a very good presentation, but I'm really loving how you're answering these questions. And guys, if you're thankful for Tony, please like the video and share it with some of your friends. All right. And then here we go. We have Cray on YouTube. What takes precedence, city codes or ADA? So you kind of hit it a little bit, but go ahead and.
It depends on what property. Mm-hmm. So what type of property? If we're talking about a commercial property, so let's say it's a strip property with 3 units in California, and we were putting a design together. We are going to be, what typically triggers the design is a lawsuit. Now, the lawsuit is filed in federal court, so that's going to trigger 2010 ADA guidelines. So we have to pay attention to 2010 guidelines, and currently would be 2022 California Building Code with 11B. 11B is more stringent. So when you compare the two, you have to take the most stringent. Give you an example. When you come through the tenant's doors for a beauty salon, the first point of service usually is the receptionist to make your appointment. That counter, according to the ADA, will be 36 inches high. And it will be for a forward approach or a parallel approach. Now, California says it has to be 34 inches high. So California is more stringent than the ADA. So you pay attention to the more stringent as it applies to each particular code.
Mm-hmm. Well, you hit it. He said it was a commercial thing, but you hit both the commercial. You hit the commercial, so that's great. All right, Heron on YouTube. Will a CAS report protect us if we cannot make our property ADA compliant?
I've seen a lot of defenses with the CAS report, and it does not provide the protection. Now, what it does provide is a limited form of protection, which is called a qualified defendant. So that really, let's see how there's a lot of it that gets into the legal side of it. So if you obtain a CAS report, which is what the state of California wants you to do, so you know your corrections. Now you have a CAS report. The next step is doing something to document how you're going to make the corrections. So let's say there are 10 corrections and you don't have the capital to make these corrections. You can at least engage and get the plans going forward. That will take you 3 to 4 months while you're coming up with capital. One of the most common defenses that I see for the defendants is that we don't have the capital. The first thing that a good plaintiff attorney does is they ask for an appraisal on the property. And if they find out that you have $100,000 or $200,000 equity in the property, and you don't want to make a $10,000, $20,000 correction according to the law, you will have a problem. So the CAS report, as long as you're moving forward, it can give you what they call a 90-day stay, as long as you are a qualified defendant by having the CAS report, engaging with an architect, submitting plans, or contracting. Now you can kind of kick the can down the road because the city is going to take 4 months anyway. But a CAS report does not give you a way out of complying with the law.
Great, excellent. All right, Connie, we have one building with 7 units in Alhambra. Do we need to worry about this? I have 7 carport spaces, 1 for each unit. The building was built in 1954.
7 units. I'm confident she does not have an on-site manager, and I'm confident she does not have a leasing office. So there is nothing on that property that's open to the public.
Great. And one thing that you had mentioned is if you're getting government assistance, and so would that include Section 8?
The government assistance through the Section 8 or HUD becoming involved, that would dictate that the property falls under public housing. And when it comes under public housing, there are a whole separate guidelines that is covered within the California Building Code 11B.
Got it. All right. Okay, Kong is re-asking the question that they asked before. A multi-unit apartment complex has an entry gate with a push-button combination door lever. Is this permissible? The manager's office is not a factor because it has a separate entry.
Not quite sure I understand the question, but the fact that here's what happens with apartment buildings. A lot of owners find out that the leasing office or the manager's office was originally designed and built. That was part of one of the conditions of the building code back in the day. However, they decided that they just don't use the office anymore. Now, you can't simply say that we're not using the office. You need to go back and have that approved by your planning department. And if the planning department says, no, you do not need the leasing office, then you can close it. But if it's still open, you need to have a path of travel to that manager's office or the leasing office. Now, there's different terms. A leasing office, most often in a multifamily, is open from 9 to 5, Monday through Friday, and there's a person within it, and there's access during those hours. Sometimes they don't have a leasing office, never had a leasing office, and never closed it. They have an on-site manager. The on-site manager, however, does not need to make his apartment available for people to come in. They need to create a common area somewhere within the property that's close to the accessible entrance. And you do need to provide a path of travel to this area so that a disabled person can at least inquire. If there were no manager, then it wouldn't be open to the public. However, 15 units or more dictates an on-site manager.
Great, there you go.
Everything has to be compliant through that accessible route.
Great. And so people who have rental homes, where do they fall?
If you have a rental home, it's not open to the public.
Right. There we go. All right, Cray, again, building construction prevents corrections, cannot change the underlying slab above the garage. And I think that was a follow-up on one of his questions. So I don't know if you have any comment on that.
If you have an existing building, then oftentimes you cannot comply with the code. It's physically impossible. And a lot of times CASP inspectors will tell apartment owners, well, you have staircase that comes into the main entrance and you can't put a ramp in, so just put a sign with a buzzer. Well, that isn't necessarily true, and I disagree with that recommendation. A contractor, CASP inspector, architect, they can't give you an agreement. They can't give you approval. So what you have to do, according to compliance, it's in the California Building Code in Division 2 under scoping. It talks about technically infeasible. If you cannot meet the code, you have to deviate from the code and do the next best thing. And it oftentimes is not simply putting a buzzer out there with a sign. It may be a different type of a ramp, a slope, but nevertheless, the local enforcing agency, meaning the city that the property is within, they need to approve it. They need to give you approval stating that it's okay to deviate and we agree with your design. So if you have a slab somewhere and you can't meet the code and it truly is technically infeasible, I would suggest putting a plan together, someone by myself or someone with ADA experience or disabled access experience, presenting it to the local enforcing agency. It's going to take a little arguing, navigating, going back and forth, because initially the city doesn't understand what you're doing when you're deviating. All they know, comply, comply, comply. So now you need to argue technically infeasible that you physically can't do it. Here's the next best thing.
Great. That's great. Eduardo on YouTube, 4-unit building. He's saying it's in National City. Really, we're talking about the whole state. It doesn't matter at all what city you're in. One rental unit is a Section 8. Do I need to worry about this? And so from what you've said before, yeah, because it's now public, it's considered public, right?
If it has open to the public, if it has any agreements with the city and it becomes Title II under public housing, which could be a small form of an agreement with HUD through Section 8, or maybe they borrowed 5% for financing, tax credits, any of those things that make it public housing, then you need to take that into consideration.
Great. All right, Dennis, 12-unit building built in 1940, assigned parking with each tenant. They have 2 spaces. There's no room for ADA parking. Is the Section 8, there are Section 8 tenants. What must I do?
If there's it's 12 units, so it's not open to the public. That would be my first scoping. 12 units, there's not an on-site manager and it's not open to the public. And I don't believe you have a leasing office. So if nothing's open to the public, then you wouldn't have that issue.
And even with the Section 8 tenants?
With the Section 8 tenant, if the building was built in 1988, you would have to be in compliance with that particular code. So what you would have to do is figure the code for that year, the previous code, and make sure the property was in compliance with that code.
Got it.
because you haven't touched it. So it was built in, let's say, 1988. It was built in that year. You don't have to upgrade it or modify it until you remodel it and touch it again.
Got it. All right. King is persistent here. We use the push button combination doorknob for security purposes. Only tenants know the combination. I want to know if the push button combination doorknob is ADA compliant. We also use a combination doorknob for the laundry room for security purposes. Is this allowable under ADA laws?
If this is, again, if it's part of the accessible route, the answer would be no. Now, I don't know how many units. I think she said in her second question that it was multi-family. Well, how many units is multi-family? It could be, 5 units or 60 units.
So let's have, the phone number is there, 714-377-9569. Give him a call.
Yes.
Con, give him a call, and he'll be able to answer it for you. And again, Tony, thank you so much for just bringing this to our members' attention. Our goal is to have the most successful group of apartment owners, rental property owners here in the state. And you providing this kind of information helps us get there. So really do appreciate it. And again, everybody, he whether it's Northern California, Southern California, he's able to get to you and give you a professional plan for what you need to do and if you need to do anything at all. So give him a call and let us know how it goes. And any last comments before we finish up here?
No, just be proactive with that CAST report. I mean, you may assume that you haven't been caught up in an ADA lawsuit, but it will come one day. So make the corrections ahead of time and get that CAST report.
Awesome. Well, there you go, guys. Okay, and for some of you in San Diego, we'll probably see you at 1:30 today. And anyway, take care, everyone. Bye-bye.
Bye-bye.
Well, thanks, Tony. Appreciate it.